I'm Mary Nolan.
And I'm Faith Pejsa.
And today we are going to discuss Chapter 9 of Honest Work.
Most people think that the main goal of business is to sell a high-quality product at a reasonable price. And because of this, we assume business transactions are a one-time deal. However, there are multiple transactions over a long period of time, creating a relationship between consumers and businesses.
Yes, it's about creating these high-quality products, but it's also about taking responsibility for when something goes wrong. Accidents happen, and that's a part of everyday life. So Chapter 9 discusses what happens when these accidents occur.
Before we move on, there are some important terms to understand when talking about product liability. The founders are a visionary group of elite legal theorists from prestigious law schools. They changed common law by applying economic theory to tort law. Thus, they became the founders of modern tort law.
Tort law is the law of accidents and injury. It is a civil wrong that causes an individual to suffer loss or harm, resulting in legal liability for the person who commits the tortious act. Negligence is a failure to take responsible care to avoid causing injury or loss to another person. Product liability is the legal liability a manufacturer or trader incurs for producing or selling a faulty product. Strict liability is a liability that does not depend on actual negligence or intent to harm. It bypasses common sense practices and holds companies responsible, at least financially, even if the absence of an argument that they could have or should have avoided the harm in question.
A reason that tort law is so common within the business world is because of the common want of a risk-free life. In Being Good by Simon Blackburn, he discusses the idea that ethics can give us freedom from the bad, but the fact is that it minimizes the bad while maximizing the good.
This is similar to consumers wanting a risk-free life and having the thought that these laws can help with that. But having these laws set in place does not prevent the accidents from happening. Rather, it helps protect consumers and businesses when accidents do occur. With that, we will later discuss liability in a few cases that were given to us in the book. But first, how do you become liable for a situation? In tort law, when determining cause and liability in strict liability cases, there are three components that a plaintiff usually needs to have.
The three things include: plaintiff suffered from harm or loss, an act or omission of the defendant caused the harm or loss, the defendant was at fault in so acting or refraining from acting.
To further discuss causation and liability, we would like to use a case from the book. In Summers v. Tice, the plaintiff had gone quail hunting with the two defendants. While hunting, they spotted a quail come out of the trees and both defendants decided to shoot. Instead of hitting the quail, the plaintiff was shot. They did not know which defendant had caused the harm because both had shot at the same time in the same general direction.
The court found both defendants guilty and to share the cost because it could not be determined which defendant caused the harm, but both had acted negligently. In this case, in order to not be at fault, the defendants had to prove themselves not guilty or liable.
Liability cases are not black and white. There are many factors in determining causation. Sometimes it can be difficult to see the accident and determine who should be held liable for the damages. If one defendant had proved that he did not physically cause the harm, would it be fair for the other defendant to take the blame when they both acted negligently?
Another example in use of the book was a negligent driver that had almost hit the plaintiff earlier that day. Even though he hadn't caused harm, he still acted negligently. So should he be held responsible for his actions? The best way to fully understand liability is look at different case examples. At the end of each case, we will give you some questions that we would like you to think about between now and Wednesday.
The first case we are discussing is called the skateboard scare. In general, skateboards present a hazard to consumer safety, but this case focuses on liability on a local level. Brewster was a skateboard shop in a smaller town. They didn't manufacture skateboards, but sold them. At one point, they posted an advertisement that included a person doing cool tricks on the skateboard.
A family bought a skateboard from Brewster, and one of the kids ended up breaking their arm. They claimed that Brewster was at fault because the child was trying the tricks he had seen in the advertisement. They also stated that the advertisements made the tricks look too easy.
After much deliberation, the committee that was looking at the case decided the ads needed to be taken down and that there needed to be a prominent posting of all the threats and risks of skateboarding next to the product. Consumers needed to read all risks before purchasing, and if there was no change, the business would be closed down.
Do you think it's the responsibility of the store owner to explicitly state the risks, or is it up to the consumer to know their skill level and not try tricks they can't do? Do you believe Brewster is liable for the damage?
Have you heard people say that aspartame is the safest alternative to sugar because it has been so heavily tested?
Our next case looks at the process of aspartame getting approved by the FDA for beverages such as Diet Coke. In order to have a new substance approved for consumption, multiple tests must be completed. Originally, aspartame was approved by the FDA for specific usage, but it was soon released that after animal testing, aspartame could lead to brain damage. Sir Lee, the company producing aspartame, was under investigation, distorting the safety data to get FDA approval.
Immediately following, the CEO invited the Justice Department to investigate, where a grand jury brought no indictment. An organization called the UAREP had 8 universities participate in a study where they found nothing improper about how Sir Lee interpreted the results. However, they failed to consider the design and execution of these experiments. A panel was put together and they suggested that the FDA keep aspartame off the market.
Ronald Reagan became president, and Sir Lee approached the FDA again, and it was approved in 1981 for tabletop sweetener and ingredient in dry foods. In 1983, aspartame was approved for carbonated beverages.
Because of these warnings, who should be responsible for taking action or be liable when something goes wrong? The regulatory agency or the manufacturer? Is it the responsibility of the consumer to know the facts and what they are putting in their body? The next case is titled Living and Dying with Asbestos. Asbestos is a fibrous mineral used for fireproofing, electrical insulation, building materials, brake linings, and chemical filters.
If exposed to asbestos for 10 or more years, people can develop inflammation in the lungs or mesothelioma, which is a cancer in the chest lining.
As early as 1932, the British documented potential risks and hazards involved with inhalation of asbestos dust. However, there was a theme with Asbestos Manhattan that the less they knew about asbestos, the better, especially for the employees. Even industry officials sought to deny workers early evidence of their asbestos.
There are so many asbestos-related cases that the court ordered the company to set up a trust fund valued at $2.5 billion to pay Mandeville's asbestos claimants. Shareholders were asked to surrender half the value of their stock. Over the years, asbestos-related litigation has expanded. More than 200,000 cases are pending nationwide against more than 1,000 companies. Out of the 91,000 cases filed in 2001, only 6% of the plaintiffs have actually suffered from asbestos-related diseases. The other claims were due to anxiety over the risk that they might have asbestos.
Is our legal system adequate for handling this problem? Should the asbestos companies be punished in some way, or is it their liability to civil lawsuits sufficient?
Our last case is Merck and Vioxx. Vioxx is a potentially harmful arthritis drug that was sold in over 14 countries with approximately 24 million patients taking the drug.
Vioxx was voluntarily withdrawn from markets due to a clinical trial that showed it tripled the risk of heart attack and stroke for those taking the drug long term.
After multiple cases, courts decided a trust fund needed to be made for people who developed issues with Vioxx, similarly to the asbestos case.
After 10 hospitalizations and a triple bypass since his heart attack in 2000, Maryland resident Gilbert Teets is confident he'll get a share of Merck and Company's $4.8 billion settlement. In a major change of legal strategy by Merck, the deal includes compensation for Teets and thousands of other users of the drug Vioxx. But Friday's word of the settlement has left Teets with mixed emotions.
I'm happy that 7 years after my heart attack, that it's over with. I'm still angry, though. I'm still not happy. This changed my life.
Merck pulled Vioxx from the market in 2004 after its researchers determined the drug doubled the risk of heart attacks and strokes.
Do you think more action needs to be taken on these drugs, or do you believe the trust fund is enough to help those who have been negatively affected by Vioxx? As we can see by these cases, it is not cut and dry on the results of what happens when accidents occur, but that is why tort law is in place. We are going to do a quick review on what we have covered in this chapter.
Chapter 9 of Anna's work basically talks about the fact that accidents happen and they cannot be avoided. However, the way you move forward after these accidents occur can make or break business-consumer relationships. But with tort law, that tries to limit the amount of damages and be able to see who is liable with the least amount of trouble as possible. We want to thank you for listening today.
And we will see you on Wednesday.
Bye.
Bye.